Our next presentation is on R forms and what everyone can do to avoid mistakes and any issues that may come up with your filing of R forms. So with that, please welcome our Rehab Policy Specialist at the department, Mike Hill.
Well, we're here today to talk about something that's near and dear to a lot of people's hearts because I've been hearing from all these updates that we should come in at least once and talk to you about how to complete R forms and provide any kinds of examples to make your jobs a lot easier. So if I start off with this, I would say if I can show you how to save anywhere from $125 to $1,000 per year and at the same time reduce the time you spend on paperwork by 10%, what would that be worth to you? If you've been in the workers' comp system for more than a year, you know that this paperwork doesn't need to be explained to you. If you're not writing reports, filing forms, or keeping track of your invoices, then you're not getting paid. Planning for success takes organization on your part, and if you're going to be successful, or as Benjamin Franklin said, by failing to prepare, you are preparing to fail. He also said that time is money, and everyone here who works for the billable hour certainly knows that that's true. Some of you may recall from past updates and presentations that I suggested that you make this web page a favorite of yours, and I'm doing that again today. It was really created to make your lives easier. If nothing else from this web page, take a look at the arrows that we have here that are highlighting the different points. Now, the green arrows, the very first one talks about how much you can charge. The commissioner came in today and he talked about the fact that the QRC rate is going to be going up on October 1st. That's where you can go and find it in that very first arrow. Now, the second and third arrows down, they allow you to sign up to receive information from the department regarding new laws, policies. It talks about common mistakes that providers are making. And it also gives annual statistics that you might in turn use to market your services. The fourth green arrow provides answers to common questions such as, if an insurer's IME says that the employee doesn't have any limitations and the insurer instructs you to close down your file, should you do it? There's an answer there. Look it up. Oops, too far. The red arrows are quick links to the laws and statutes which Kate was talking about earlier, so that you can keep abreast of that. And of course, the yellow arrows are where you find the most current R forms to use. And I would suggest that you check the R forms at least 1 to 2 times per year. The best time to check it, of course, October 1st when you're looking at the new rates, right? Maybe around April when you're doing taxes, just to make sure that you're up and using the most current form. One is the rules require it, but number two, when we're looking at making sure that the department is getting the most current information, that's important to us. Additionally, there's training materials that are in there, and that's from all the past updates. So the people that are doing simulcast right now, they had to go over the training materials area. Just go ahead and download the forms that you have in your folders today. So it's a nice review. Now, as you recall, Ben Franklin said time is money. He also said that wine is constant proof that God loves us and loves to see us happy. So listen to Ben Franklin, all right? When you go to DLI's webpage in the R form section, you'll find that they talk about what the rehab form is, and they also talk about the version date. And that's what I was referring to earlier. Make sure that your form is the most current version. And yes, to your question, have QRCs been disciplined for using outdated rehab forms? The answer is yeah. In fact, most recently here in 2016, I had a QRC that was using forms from 2008. 8 years old. So again, we want you to go ahead and make sure that you're using the most current forms that are around. Now, as a reminder, the R forms, reports, and correspondence should have the employee's name on there, their WID number, worker ID and identification number, or the full Social Security number, either the WID or the full Social Security number. Do you have a question?
Yes, I've noticed lately when I'm filling out forms, it doesn't print out the full Social Security number. There's like the last number isn't taken on your form.
On the online forms?
Yep, R3.
All right, send me an email. Give me a specific example of a case in which she was saying that she was printing out the forms and it's not providing the full information. What you do in that situation is send me an email. Give me the specific case, the name, the social security number, the date of injury, so that we can look that up and work with our IT department to get that part fixed. Otherwise, if we don't know about it, we can't fix it. Let's see here, where are we at? And again, as a reminder, if you're just using the last 4 digits of the social security number, that's not acceptable. So again, the full social security number or the WID number, what we're looking at. Rights and responsibilities form. We've all seen this when we do the rehabilitation consultation with folks. And the first green arrow reminds us to disclose any affiliations, business referral arrangements that we might have with any of the parties, employer, doctors, attorneys, and that. I had a QRC that I worked with once that disclosed to me that he was the exclusive QRC for that employer for the past 20 years. Yet, on all this rights and responsibilities form, he indicated that he had no business referral arrangement. Well, the second green arrow reminds QRCs to provide copies of all documents they receive or generate to the employee and to the parties. This includes email. Let me say that again. This includes email. We want to encourage transparency because if the employees understand what's being said about them, they can be making informed decisions about how their rehab plan should be going forward. The last green arrow is the form on the date of when that was created, which goes back to that slide number 6 that we were talking about earlier. The back side of the rights and responsibilities form, there's really 2 big points to be aware of. The first one is that under that disclosure area we have 3 boxes, right? 2 out of those 3 boxes need to be completed. The first one, of course, is that the employee has understood their rights and responsibilities as explained to them. Now, the second and third box, one is that you have either disclosed that you have a referral arrangement with one of the parties, and you've provided that to them in writing. The other box is, listen, I have no referral arrangement, and I've informed the employee of that. If you're marking that you both have a written disclosure that you've given to them, and you have no disclosure or a business referral arrangement with them, somebody is confused. Either QRC that's explained it to them or the employee that's understanding that. So 2 out of 3 boxes are what we're looking for, so we understand that they know what their rights and responsibilities are and if there's a business referral arrangement or not. Of course, when the rights form gets sent in, it should be sent in at the same time as the consultation report form is sent into the department, which is within 14 days of the first in-person meeting. If the employee doesn't want to sign the rights and responsibilities form, write in the box exactly that. You reviewed it with them, but they declined to sign. Why is that important? Because we know that you did your job. You did explain it to them, but they declined. And that's important. The consultation report form, it's going to be telling us a couple things, which I'm trying to find where I'm at, tab. Let's see here. The red arrow on the right is the answer to the, all right, I'm trying to look here. My opinion, okay. So one of the things that we're responsible for is answering questions 20, 21, 22. And trying to make a determination where the person is qualified or not qualified, or they're precluded from their job. In your opinion, will they be able to get back to the job? And of course, will they need any kinds of rehabilitation services? Another part here too in the yellow one though is that you talk to the employer. Can't encourage that enough to find out if they have a job for the person to return to. There's a lot of situations in which the employee has been terminated from the job. You go, well, he was just terminated last month. Obviously, there's no job to return back to. One of the things experience will tell us is that a lot of times the insurer will talk to the employer and there will be a job opportunity. So it's always worth and valuable to go ahead, contact the employer to rule that in or out, and use that part of the information as you're making your determination. In box number 24, if you have a situation where you have found the employee to be qualified, and the insurer has said, listen, I want that person to be qualified whether you find them qualified or not, then mark, and the employee agrees, go ahead and mark box C only. We don't want a number of boxes checked there. We just want one box checked to let us know that. If the employee is not qualified, and I've had this happen where I've worked with burn patients, and the insurer said, listen, whether you find them qualified or not, I want you to work with them because I've always had these cases go south. And if the person is not qualified, talk to the employee and say, listen, employee, I found through this consultation you're not qualified, however the insurer is offering services. If you're in agreement, I'll go ahead and provide services. If the employee is in agreement, mark box number C, and that's what gets sent in. The other part that's right above the signature line is it talks about attaching a narrative report to explain the basis of your determination. That narrative report should be attached to that consultation report form and sent, of course, to all the parties and to the department. Explain why you found this person to be qualified. The statement doesn't have to be very big. It can be in 4 or 5 paragraphs. It can be talking about, these are the facts of the case, this is why I found this person to be qualified. It's not a reiteration of the yes-no questions that you were asked on the form. We can read the form. We really want you to tell us why you thought this person should be receiving services. Maybe it's based on the fact they have this lumbar condition the employer doesn't have a job for them to return back to. This is why we feel the person needs to go ahead and have the services provided to them. The last little part you have on there is the CCs as to who the parties are going to. We know in the rehab rules that who's supposed to be copied? Employee, insurer should be getting a copyright. If there's attorneys that are involved, they should be getting copied on that. One of the things that it's easy to do is always just assume that clerical staff is going to remember who forms are sent out to. Don't assume. A lot of people are carrying caseloads anywhere from 20 to 35, maybe higher cases. At the end of the month, your clerical staff is trying to work and generate and get all those forms out. It's a lot for them to remember who all the different CCs should be going to. Make it easy for them. Put down the names of the people that it's supposed to be going to. It's also helps you to make sure and to justify, listen, I'm doing my job of making sure that all the parties are copied. The only other part that I always do is talk about the heading up there. Who's it regarding? What's their WID number, date of injury, that type of information. Kind of put it in your mind that all this information is coming to the department. And you've got this person who's carrying all these stacks of forms, and if they drop it and everything separates, we should be able to put all that stuff back together again. So marrying up the narrative report with the R form. So please make sure you do that for us. Brain teaser, what if the employee doesn't want to meet with you for a consultation and doesn't want rehabilitation services? What should you do? Anybody? The answer is send in a letter to the department and then tell us what happened. Remember that the insurer is under obligation to have a consultation performed within 15 days. They're responsible for that. One of the ways to make that insurer happy is you say, listen, department, we attempted to do this, but it couldn't happen. And then by sending this letter to the parties, it does a couple things. It explains what the situation was. It also talks about, listen, if the employee changes their mind, what can they do? So they know what their next steps are. Because, things change in our lives. And of course, along with that, all the parties are copied. If you copy the department, we know then that we don't have to be bugging the insurer about where is that consultation report form. So it makes that referral source happen. Another brain user, you see the referral with an employee who received a blow to the head. There's a right shoulder tear. When you meet with the employee and his spouse, you learn the employee has difficulty focusing on conversations, making informed decisions, and as they've been married for 20 years, the spouse feels she can answer for him. Have you ever run into that before? Yeah. What should you do? Well, if that employee cannot be making any informed decisions, it's probably best to go ahead, again, write a letter to the department. You're not going to be able to explain the rights and responsibilities form to the person. They're not going to understand because of either the effects of the injury or maybe the medications they're taking. But again, what you've done is you said, listen, this is what's happened. If things improve, then these are the steps the employee can take to be able to go ahead and request another consultation. They can follow up with you. They can follow up with the insurer. They can contact the state and say, listen, I need a consultation. So always leave them with something that they can go ahead and carry on to that next step.
What if the spouse has power of attorney?
Pardon me?
If the spouse has power of attorney?
If the spouse has power of attorney, you can certainly go ahead and have the spouse work with you and answer the questions. The thing about power of attorney is that they're awfully tricky. And it's a hard one to decide on because there's certain things that a power of attorney allows them to do and doesn't allow them to do. And at that point, I guess I would say if they have an attorney, we probably would refer them to the attorney to figure out if that spouse could even be answering these questions. It is a real tricky point. What if you go through a consultation, you find the employee to be qualified to receive rehab services, but they don't want them? Write a report. Well, that's pretty close to being true. You write a narrative of what you found. And you indicate that I found the person to be qualified. The employee has turned down the services. And again, what do? If the employee changes their mind, this is what they can do to go ahead and request another consultation. R2. We periodically get R2 rehab plans in, and they have some typical errors that are involved. One is that we have QRCs that will go in, and they will fill in almost all the service categories, whether they intend to provide them during the time period or not. They'll put in medical management. They'll put in vocational testimony. They'll put in on-site job analysis. It's amazing all the things that they will find that they will be putting in. And they said, well, it might happen. Well, the only thing we know for sure is that the sun is going to come up every day, right? So the thing that we really encourage QRCs to do is talk about the plan for now, what is it you intend to provide, and list those areas, and provide us those projections that go along with that. It eliminates a lot of wasted time on your part writing out those extra services, which you don't have to do. Remember, we're on the billable hour, so you might as well go ahead and use that time for something else. And it eliminates the visual clutter. Service category overload. Assuming that one rehab service is going to go ahead and cover multiple areas. I've had QRCs that have written down on the R2 plan medical management. And they've used medical management to cover their administrative costs, to cover their contact to the employer to figure out if there's a job available, to cover job modifications, a number of different things. We have plenty service categories that are listed on there. List exactly what the services are that you're going to provide, because one service does not cover all areas. Turnaround. Each party, including the employee, has 15 days upon receipt to return the plan. I can't tell you how many times I've talked to QRCs over the years that have sent R2 plan out to the employee to go ahead and sign. After a couple of months, they still haven't received it back. Well, the one thing is that if you're sitting at your desk and you get an R2 plan that's signed by the employee, you know that automatically you need to go ahead and turn it off and send it off to the employer. It's a trigger point and a memory point. This is what we need to do automatically. But if they don't send it back, we don't think about sending it off to the insurer for the review and signature. If that R2 is not filed, then that plan is not in effect because it's still sitting with them. So there's no difference between the employee and the insurer with respect to that 50 days turnaround period upon receipt of the plan. So create a tickler system, whether you use a paper calendar, whether you put it into your Google system, automatically set that up so that when you get it or you don't get it, that you know that at least you attempted to do that. Let's see here. Well, one of the things, too, is filing evidence that you went ahead and attempted to get that R2 plan off to the different parties to sign. If you send it off to the insurer and the insurer didn't return and sign it, attach a copy of that cover letter or fact sheet with the R2 plan that shows that you did your job. It shows that you did your job. It's required by rule, which is that 5220410 rule. And it allows us to know that that part is there. The other thing is that for anybody who's doing the online system, you can attach those copies of those cover letters on the online system. So it's just a click of the fingers, save yourself some postage. And let's see here. Failure to file, we talked about that. The R2 plan, one of the most common areas that we find with R2 plans is that the highest grade that the employee has achieved is not listed on the R2 plan. So what ends up is our department has to then contact you to find out, was it high school, was it not high school, was it college, how much college, etc. Please indicate how much education that they have. Also, too, a big part for us, the actual rehabilitation consultation cost. It's not a projected cost. We want to know what was the actual cost. I worked with a QRC once who wrote down $200 on her R2 for everything that she did. This was for both here in the cities and outstate Minnesota. Of course, the way we figured out there was a problem was we were looking at the R8 and her invoices, which was a little over $1,000. So we need to make sure that you're going ahead and putting down the actual costs. Initial evaluation report needs to be attached to the R2 form when it gets sent out to the parties. Let me say that rehab consultation and the initial evaluation report that goes with the R2 are two separate forms. Two separate forms. If the person is not qualified at the time of the consultation, what are the parties going to care about their education, their vocational background, medical, all that other kind of stuff? They only want to pay for those 4 or 5 paragraphs. They don't want to pay for an 8-page report. Make sure that these things are separate. And that initial evaluation report that goes with the R2 is going to be providing those parties with a lot of information. You want to find out what is the vocational, not just the job that they're in today, but what was their work history through that. Because that's going to be helping you to figure out what? Transferable skills that they might be able to utilize with the current employer. For the job placement vendors, that's valuable information if they have to be building resumes later on. The R2 form, of course, has got to be filed with the department within 45 days of the first in-person meeting. One of the things that we want to do is make sure that you cover all 8 points. Starting off with medical. We got some vocational. And you've got education, you've got the social history, you've got the economic factors, transferable skills, employment barriers, recommendations, etc. The rehab rules also, I don't know how many know this, that require you to go ahead and put your QRC number on reports. Everybody know that? Okay, that's good. Again, list the names of the parties of who the copies are going to go to. We already talked about not assuming that the clerical staff will know. And let's see here. This is an example of a letter to send to the insurer along with the R2 plan and narrative report, which covers the 15-day rule. This is a memory jog for them that they need to review it, contact you if they have any questions or concerns, and or if you don't receive it within 15 days, you're assuming that it's going to go ahead and be approved. If The purpose of these letters really is, though, is that if somebody is not returning the plan and not signing it, it proves that you did your job. So if you attach that example with the R2 plan, we know you did it. If the employee signed or the insurer signed, then we don't really care about that part. Obviously, they did it. Let's see here. If you wanted to provide additional evidence, you could write an example letter like this to the department that, you would send it off and the employee signed the R2F and the insurer did. But it's not all that important if we're getting the actual copies of like the cover letters. Getting your invoices paid can be a challenge. I mean, I assume there are probably some people here that never had to deal with that, but it happens to some folks. It can be very challenging for the insured to determine what should be paid, especially since several firms have their own invoice version, which is different than everybody else's, right? Information to be included in your invoices is in the Rule 5220, 1900, Subpart 1A. 1900, Subpart 1A. Take a minute to take a look at your invoices and make sure that you're covering all those points. Another way to do it too is you can certainly go to our website, which has an example invoice form that you might go ahead and utilize. This is covered in our form section. So if you go down towards the bottom, you can find that. But you want to make sure that you're hitting all those points, so if you're challenged on that, then you've got something to stand on. One of the other things that's really important is to make sure that your staff is coding the invoices correctly. This is an example of an invoice in which the QRC firm didn't use the full Social Security number. You can see up there towards the top. And during the course of the investigation, it was determined that the QRC's administrative staff used the 09 code for everything that the QRC was billing. Does everybody know what the 09 code is? Job Seeking Skills Training. So she was doing job seeking skills training for the consultation, for medical management, for doing the R2, for doing everything. You're responsible for making sure that your administrative staff working under your direction is doing what they're supposed to be doing. The other reason that this is important to us is when we're getting back to that R8, and you're putting down all those service categories and stuff, the department is looking at that stuff. And we're tracking that stuff because we're trying to figure out where all the expenses are. So we want to make sure that what you're sending to us is correctly coded. The great Yankee baseball legend, Yogi Berra. Has everybody heard of Yogi Berra? His famous saying was, when you get to a fork in the road, take it. What does that mean? Critical thinking is something that rehab providers should be doing all the time. What's happening now? What are the problems encountered? And what should happen next and why? The plan progress report is to be filed 6 months after the R2 plan is filed. This is the form and point in which time you should be doing critical thinking. It tells the parties how much money has been spent to date, how much additional time is being projected to be utilized. It's also an opportunity to stop and think about what's happening with the file, provide answers, stating quick resolutions to those kinds of questions, and what will make the file move forward. And it's also a way to justify costs. Sometimes people go, hey, why are you spending so much? And you start saying, here's what the problems are. Now, if an R-3 Rehab Plan Amendment is going to be used in lieu of a plan progress report, then you need to make sure that you're filling out items 20 through 23. Okay? Is it being used as a plan progress report? Yes. We got a yes/no question. If you don't write in yes/no, then we assume that it's not. Right? even if you fill in the other stuff. So let us know if you're going ahead and planning to do that. And let's see here. And it's the same thing. Now, the in lieu part, of course, is can you file a plan progress report instead of an R3 if you need to extend the plan? No. No. So really, when you're thinking about that R3 with the PPR, it's being used in addition for the PPR part. Let's see here. I lost the page. What barriers might you uncover? One of the things that we find is you're asking for this critical thinking, what are the barriers? Well, the fact is, maybe the employer can't take the person back to work. Maybe they don't have a high school diploma. Maybe the employee's been doing the same job for 20 years, so doesn't have much for transferable skills. Maybe there's an area of high employment, so it's going to be more difficult. So start talking about what are the problems in the area. Don't just assume that because you're a great QRC, which I know most of you are, that you're going to be able to fix everything. Talk about what the problem is. Talk about the solutions. If the person doesn't have their GED, that's a barrier. Maybe during the time period they're in medical management, they can be doing GED classes, right? Or adult basic education. They need to be able to brush up on some skills enhancement. Maybe taking a Word program or an Excel program or getting familiar with the computer in the first place. Talk about the things that are going to help move the plan along while the person is needing those kinds of services early on. R3 Plan Amendment errors. As with the R2, don't list services that you're not planning to provide at this time. Don't write in no change on the services. We don't know what that means. Let's face it, if you're doing medical management early on a case, usually the expenses for the medical management are going to be a lot higher because you're doing a lot of doctor stuff, right? All right. But as we're getting closer towards the end, it's going to be less. Talk to us about what you think the actual projected costs are going to be. So list out the ones you tend to provide and what you think the costs are going to be. Same with the R2. Every party has got 15 days to sign, review, return it upon receipt. If they don't, move the plan on to the next party for review signature so you can get it filed with the department on time. And of course, again, if there's any party that doesn't sign the R plan, attach a copy of that cover letter, send it in. So we got evidence that you did what you were supposed to do. The R3, of course, is to denote any changes in goals or services and or to extend the rehabilitation plan. Again, if you file the R3 without a required signature, provide evidence, we talked about that, that as far as the facts, the cover letter, etc., that you send it off to the parties. It's a good practice, and it's also a rule. What can you say about a change of QRC or a change of vendor? Usually somebody is disappointed, and usually somebody's happy about it, right? It's one of the natures of this business. The rules require that the new QRC, not the previous QRC, file the R3 that shows the change. Previous QRC should send a copy of the file to the new QRC, along with a letter with a breakdown of the services that were provided. With that letter, with the breakdown of services, we strongly suggest that you go ahead and copy the department on that. Why? Because sometimes the new QRC doesn't file the R3 form, right? So when the department is checking for forms and looking for issuing penalties, the first one that we're going to go bug is the last QRC of record. You don't need us calling you. It's a waste of your time. So automatically send us a copy of that breakdown letter. We know where that plan is at and who to go ahead and contact. Now, I will tell you that there are QRC firms out there that require employees to sign a release of information before they'll send a copy of that rehab file to the new QRC. Yeah, it's probably a good practice to go ahead and adopt. The rules don't say anything about it very specifically about it, but it's probably a good rule. Something to think about. Here's an example of a letter to the new QRC with a breakdown of the service costs. When sending the rehab file, let's see here, you don't have to make copies of that whole file and send it to all the parties. You just need to send it to the new QRC, right? Because they probably already received all the information from your work that you've been doing it along to save yourself some money. Now, according to the 5220.0510 rule, subpart 3A, the new QRC must file an R3 with the department within 15 days after receipt of the file. Okay? Now, there's some QRC firms out there that believe the new QRC, as soon as that they understand the file is going to be transferred over to them, that they need to generate an R3. The answer is false. Get the file, work on the R3, tell us the services that you're going to be providing, send it to the parties, send it off to the department. Of course, the second page of the R3 shows that the previous QRC's plans cost, and now the new QRC's projected cost. Primary denial of liability. Is there anybody in here who's not dealt with that yet? We got 2 people that have never dealt with primary denial. You're really fortunate. Well, I'm going to tell you right now that according to Mark Twain, denial ain't just a river in Egypt. In workers' comp, the insurer may decide to not accept the claim, and or they may believe that the injury has been resolved. The QRC typically receives something from the insurer about the denial. If the employee decides they're not going to dispute the denial, then you can close the file on agreement of the parties. However, if the employee is going to dispute the insurer's findings, they need to do so by filing a claim petition. As the QRC at that point, you need to decide whether you're going to go ahead and work that file, risking the possibility of not being paid, or to transfer it over to the department's voc rehab unit. If you're going to go ahead and transfer that file over to the voc rehab unit, then there's the P.O. box number to use. Don't send it to 443 Lafayette. Send it to this P.O. box, okay? Of course, here's an example cost breakdown letter to send to the VRU with a copy sent to the parties. Only when a rehab file is transferred to the VRU due to a disputed denial of liability does the previous QRC complete the R3 showing the change of QRC. Remember all the way up until that point I said it's always the responsibility of the new QRC? This is the exception to the rule. Primary denial of liability, you create one that shows it's being sent over to the VRU. When the VRU goes ahead and picks it up, they're going to be filing their own R3 on top of that. But that's the exception to the rule. And it basically tells the parties what happened and where the file is going. Sometimes you may receive a copy of this form, which is the insurer's denial of liability. Attach that to the R3 form that you're sending out with copies to the different parties and to the VRU that says, listen, yeah, we've got some formal notification. Or if they don't send it to you, but you got an email, attach that. So at least we have some kind of understanding that this is what the insurer is doing. For several years, the department has been telling QRCs that they must have a current rehab plan. Just whether you are providing services or the rehab plan has been put on hold through agreement of the parties. The key suggestion here is to list specific dates that the plan is going to be suspended. We suggest you go ahead and leave yourself 3 or 4 weeks beyond that so that the plan remains current. So here's an example of an R3 plan with the plan put on hold. And you can see we talk about the dates of when the plan is suspended. So everybody knows that. The other part, though, why do we go ahead and list down the services anyways? The parties sometimes have a habit of changing their mind, right? So you want to be able to hit the ground running with the employee. If they say, listen, we're going to go ahead and resume services, that you can go ahead and start doing those. And show evidence that, you can get paid. Expired and missing R forms. This rule here was instituted back around 2008. I don't know if you've ever received any letters from the department saying, you need to send us a copy of your R2, you need to send us a copy of your R3 or R8. This is the rule. This is all involved. And it talks about the different penalties that are involved. The first penalty is if you don't respond, it's $125. You still don't respond and the department sends you off another notice, it's $375. $125 plus $375. Now we're at $500 for not responding to the department within about 42 days, right? If the department has to contact you again, it's another $500 on top of that. $1,000 for a single R form. Who could use $1,000 someplace else? Landscaping, vacation, maybe those other important things in life. So the big thing on this one is if the department contacts you about missing R forms, get a copy to them right away. If you get fined, don't just pay the fine and not send in the R form and assume that you're in good shape. Because if you pay the bill, we don't get the R form, there's another $375 fine coming your way, right? So avoid that. Let's see here. In case you're wondering what the department's letter looks like, when we send it to you asking you for those R forms, it's going to look something like that. The R8. The areas that we tend to have where QRCs are not completing, if you look at item 15, one of the things is we want to take a look at your summary narrative report. If the employee returned to a different job, then we expect you to state on the R form what that job was and details about it. So if they're working for XYZ company, their average weekly wage is, you need to have that information. If you read the August 2015 compact, you'll also know that item 21G can only be marked if there's a primary denial of liability or further denial of liability. That says withdrawal of QRC, right? So if you're just wanting to leave the case, you can't just check withdraw and close the case. It's only when there's a denial of liability that's involved there. Okay, just something to be aware of. And of course, list the actual rehabilitation consultation costs that we talked about earlier. Remember to add the 4 columns on the back side of the R8 form, and then give us the total. Otherwise, our staff has to do it, and they get really grumpy about having to do that. So it'd be really good for us. Summary or closure report. Probably heard it a million times. The R8 summary narrative is not a final monthly report. Give us an overview of what happened on this case. One of the things that you note, we don't ask you to send us every monthly report, do we? No, we don't. We're saving you money. We're saving ourselves money. But we do want to kind of know what happened on this case before you close it. We use that information, and that information is very valuable. In fact, we'll follow up with insurance companies when we find that their forms aren't corresponding with what you said. This is good for the injured worker. And as you can see, this report doesn't need to be terribly long. That was just 2 pages, right? It's a brief overview of what happened here. You can also do the forms online. You've heard this at the last update, and I'll just mention again. I understand that there's been an uptick from the last time that we did reporting on this as far as people using the forms, the online system. And the reason is it's really nice. You type it in. If you're like me, you can actually read the handwriting. And of course, you're able to go ahead, print it off, get signatures, and indicate that you submitted it, plus attach copies of the cover letters for anybody that has not submitted the forms and stuff. Let's see here. Rehab request. You can also file your R forms online with the department. The department's been issued an ID number. If you don't have it, contact us so you can get your online system number. Let's see here. behind. Go back here. Rehab requests are often filed by QRCs to obtain direction of the rehab plan when services are disputed, or for approval of retraining plans, or to get your bills paid. Okay? And in this example, the insurer didn't pay the job placement vendor for the services. So whether you're a vendor or a QRC, you're encouraged to go ahead and document the dates that you attempted to contact the insurer to get payment of your bills. And when they didn't do that, go ahead and indicate that you'd like to get payment of it. There is a penalty up there that statute does cover. It's money that's actually paid to the department, but you can certainly ask for penalties if you think that's necessary. One of the things we always tell QRCs is to save everything, right? When you close down the file, it's supposed to be saving all required reports and progress records. Say that again, required reports and progress records. Change that tongue around. And I've also heard that it's really expensive to do that. I had a boss once where he would take these big boxes of files and he would put them out in the garage on pallets. All the cases that they ever had. And I know there's some people that will verify that these files were this high. There are easier and cheaper ways to do it. Certainly flash drives right now is a possible way to do it. You can buy a 128 gigabyte 2.0 flash drive for $20, or a 16 gigabyte. A 16 gigabyte flash drive will hold 30,800 Word documents. 30,800 documents. So maybe for a $15 or $20 investment, you can get down from a garage full of files down to a little flash drive for actually very little. Another form is you can certainly use cloud computing, but you have to talk to somebody who's a techie and knows about that stuff. I'm lucky to use one of those smartphones these days. Questions?
So you've got the online ability to fill out R forms. Is there any talk about the department getting a Dropbox to submit completed R forms instead of having to fax in and get busy signals?
Oh, say that again?
So you can go online and type in all the information.
Uh-huh.
Once you get the R form sent off to the parties and it's ready to submit to the department, instead of faxing it in and getting busy signals and refaxing, is there talks about getting a place to do a Dropbox to drop that form in like a PDF?
If you're using the online system and you've completed it, you can save that form and then you can go back to it and then you can send that in electronically through the internet.
So I've got a computer program that does all my R forms for me, and then I print it off and I send it to the parties for signatures.
Okay.
Once I get it back to me, I scan it in and I email it off to all the parties. It'd be nice if the department had a website that I could just email that form to as well instead of having to fax it in. Because the fax is always busy.
All right. So what he's saying right here is that he does his forms using a different computer program. He's faxing those off to he's emailing those off to the different parties. He's getting that back. Does the department have an email system right now to get those R forms in? And it's something that has been suggested in the past that we look at. We haven't done that yet. The answer to that in the temporary piece was being able to just go ahead and use the online system because it was automatically transferred then into our imaging system. So it was able to bypass staff touching it all together. Whether they'll go and set up an email address where people can fax it instead of, email it instead of faxing it, I don't have an answer to that. But how about a second fax line? Yeah. I can certainly ask the department if they would be willing to go ahead and do a second fax line. Again, their whole push at this point is trying to go ahead and help the QRCs get this all electronically into the system, cutting down on staff time altogether.